Good morning, everybody.
Good morning.
Morning, Dave Barr from Free Eugene.
This is Karen Finnegan.
Morning. Are you guys getting weather?
Yeah, we had some snow, but it's not very bad at all.
Well, that's good.
Very good for us.
Much to do about nothing. I guess New England's getting hammered.
Yeah, certainly are.
Morning. Good morning, everyone.
Good morning.
Good morning.
Morning. Morning.
Okay, I can hear some folks on the phone. Okay, so let's get started. I would like to thank everyone who made it in this morning, despite the problems some of us faced with getting here. As you may all know from our previous meetings and introductions by Ms. Miriam Nisbet, our former OGIS director and chairperson for this committee. My name is Nikki Gramian. I am the deputy director of OGIS. At the present, I am in an acting position as the director of OGIS, and therefore I'm chairing this meeting today in that capacity. Hopefully, OGIS will have the next director on board soon, who will be able to, chair the next meeting in April. By way of short introduction, I joined OGIS in March of 2013. I previously worked at the Department of Homeland Security, Office of Inspector General, and prior to my employment at DHS, I worked at the Department of Justice Executive Office for U.S. Attorney FOIA Unit. In between my jobs at DOJ and DHS, I also worked for a very short period of time at the Federal Public Defender's Office for the Eastern District of Virginia when they first opened their doors in Alexandria, Virginia. I've had the pleasure of working with some of you on FOIA matters, so some of you know me in my previous positions. So let's now move on with the introduction of the FOIA advisory members. If we could please spend a few minutes or the next few minutes introducing the members who are around the table as well as those on the telephone. We did get some emails from some of the folks that were originally going to be present who are now going to join us by phone. Before we begin the members' introduction, as a reminder, if the committee members, if the committee members' bios are all available on our website, on the committee's webpage, which is also available at www.ogis.archives.gov. Unfortunately, today we're not able to live stream the meeting. However, we are videotaping the meeting, and we'll make the video transcript and the meeting materials available on the committee's webpage. For the record, it will help if you all can remember to identify yourself by name and affiliation when you speak. Committee members and Department of Justice Office of Information and Policy Director Melanie Pastay could not be here with us today because of a previous commitment. Two other government members and also Dave Barr and Maggie Mulvihill are also unable to attend due to previous commitments. We look forward to seeing them at our next meeting on April 21st, 2015. We can start with the members who are on the phone, and then we'll hear from the rest of you in the room. I'll ask each of you to introduce yourselves and remind the group what you do in your professional jobs. Let's start with the folks on the phone, if we could.
My name is Dave Barr, and I'm an attorney. I represent FOIA requesters throughout the country in their interactions with various federal agencies. I'm in Eugene, Oregon.
Thank you, Dave.
Hi, I'm Karen Finnegan. I am with the State Department, and I'm chief of the division that develops internal FOIA policies.
Good morning.
Hi, I'm Lee White, Executive Director of the National Coalition for History.
Okay.
Good morning. I'm Jim Hogan. I am the Chief of DoD FOIA Policy in the DoD Department of Defense Transparency Office.
And this is Dolores Barber. I'm the Deputy Chief FOIA Officer at the Department of Homeland Security. And this is Eric Gillespie. I'm the CEO of Gavini.
Ramona Oliver, the Director of the Office of Information Services at the Department of Labor.
That's it? Okay, great. Thank you. Now, for the folks at the table, if we could start with my...
I'm David Reed. I'm Assistant CFO at the Federal Communications Commission.
I'm Marty Michalowski. I'm the FOIA Manager at the Consumer Financial Protection Bureau.
Ann Weissman. I'm Chief Counsel and Interim Executive Director of Citizens for Responsibility and Ethics in Washington, or CREW.
Nate Jones, Director of the FOIA Project at National Security Archive.
Ginger McCall, Associate Director, Electronic Privacy Information Center.
Mark Zaid. Oh, sorry. Sorry.
That's okay. Whoa.
I'm Brent Evatt. I'm the Deputy General Counsel for Mission Services, Science and Technology at the Defense Intelligence Agency.
And Mark Zaid, I'm an attorney here in Washington, D.C., handling FOIA litigation and also the Executive Director of the James Madison Project.
And very soft-spoken.
Yes, with my apologies to my good colleague from the DIA.
Quite all right.
Can I guess?
Yes.
Larry Gussman, Agency FOIA Officer, EPA.
I'm Kristen Lemelin. I am the FOIA Advisory Committee's designated federal officer, and I'm a facilitator at the Office of Government Information Services.
I'm Amy Bennett. I'm at the Office of Government Information Services.
And Amy's taking notes for us today, so I don't have to, so thank you, Amy.
Yes, Amy is our newest member at OGIS. She's part of our review team, and she's kindly agreed to take notes for us today. Okay, so let's move to our agenda. And before we dive into to the work that we're all about to do, I wanted to share some details on how today's meeting will work, and also cover some basic expectation and ground rules for our session. First, we will take about a 15-minute break halfway through this meeting at about approximately 11:20. While we're not allowed to have any food or drinks in the room, we can only have water.
Unless you're at this table.
Unless you're at this table, yes, we could have water. If you all wish to grab something quickly from the cafe, which is located 2 levels down on the ground floor, which is also where the restrooms are located. Next, along with everyone's bios, as we've explained, all of the information about this committee is maintained on our webpage within the OGIS website. Again, www.ogis.archives.gov. There you can find committee's charter, members' bio, and any other links to videos, transcripts of these meetings, information about meeting dates, public comments, and anything else related to the work of this committee. As you all know, we will meet 4 times per year. This is our 3rd meeting. Today's meeting agenda and the OGIS website is at the OGIS website, and it lists the dates of our upcoming meetings. We selected Tuesdays of the 3rd week of the month, unless the date conflicted with a holiday. During our inaugural meeting, we established 3 subcommittees: the subcommittees on FOIA and oversight and accountability, the subcommittee on proactive disclosures, and subcommittee on FOIA fees. These subcommittees are free to schedule meetings in addition to the larger committee meetings. The same FOIA rules apply to the subcommittee meetings, and we can expect to see notice of those meetings and that they're open to the public as well. Subcommittee documents are also available on the committee's webpage in case somebody wants to review those. Today we will hear updates from each of these subcommittees, and we will also discuss the draft bylaws for the committee. This is a committee on freedom of information. Accordingly, we want our work to be as open, transparent, and participatory as possible. We're glad to see so many interested folks in the room, and we want everyone to be as much of a part of this committee as possible. I should also note that we have set aside a period of time at the end of the meeting for public comments. We want to hear from everyone in this room today, and we look forward to hearing from any non-committee members who might like to comment at the end of the meeting. To learn more about subcommittee comments to this committee, please visit our site and look for Contact Us, Submit Comments page. Now, if we could just take a few minutes to take care of two very important administrative matters. One is the approval of our minute meetings, and for the October 21st meeting. The committee members have had a chance to review a copy of the minutes from the October 21st, 2014 meeting. A copy was emailed by Krista. And
you also have copies in front of you right now. And if you're in the studio audience, these minutes are available online.
Right. If you all would take a few minutes to review what's in front of you and let us know if there are any corrections to the meeting minutes. Anybody? Any corrections? No? I guess your silence means no. That's great. We'll now entertain a motion to approve the minutes. Do we have a motion?
So moved. Second.
All in favor?
Aye.
All opposed? Excellent. The minutes are approved. Anyone on the phone? Okay, great. Thank you all. Now if we could also move to our next topic for the committee's vote, and that topic is our draft bylaws. The Federal Advisory Committee Act, FOIA, requires advisory committees to develop clear operating procedures to govern advisory committee activities and meetings, and specify the relationship among the advisory committee members and the designated federal officer, Krista, and the agency staff. On November 13th, 2014, the committee's bylaws working group, consisting of the former committee chair and OGIS director Miriam Nisbet, Ms. Melanie Postay, Ms. Ginger McCall, Mr. David Reed, and also Mr. Larry Gottsman. All met and to discuss and agree upon the language for the bylaws. The November 13th bylaws that Krista circulated to the committee members reflect the changes to which the working group agreed upon. Please note that the bylaws were modeled after the examples that were posted on GSA's website, and it also reflects the basic intentions for the way this committee will work. As you can see, they're fairly brief and straightforward, so if we all could take a few minutes to review and discuss any questions, comments that anybody has. Okay, great.
Nikki, my only comment is I'd like to thank my colleagues who worked on developing these bylaws.
Noted. Thank you. Thank you. Great. We will now entertain a motion to approve the bylaws. All in favor?
Aye.
All opposed? Wonderful. Anyone on the phone? I guess not. Okay, the bylaws are now approved. All right, great. So before I turn the microphone to our subcommittee members, are there any other topics that we can discuss that you all need to discuss? No? Great. Okay, so now we will spend most of the meeting time to hear from each of the subcommittees on their work. Krista and I will keep time, and we will spend about 30 minutes on each subcommittee's report, including a report of where each subcommittee work stands, and if there are any discussions or brainstormings you all would have to discuss with your fellow committee members. Let's also make sure that each subcommittee has a clear path forward for the coming months as they continue working to make recommendations to improve FOIA as directed upon the creation of this committee in the second Open Government National Action Plan. With that said, would like to ask the Subcommittee on Proactive Disclosure, co-chaired by David Reed and Eric Gillespie, to present their subcommittee reports. And I understand Mr. Gillespie may have to leave early today. If that's the case, we'll just have Mr. Reed. Great, thank you so much.
Okay, thank you, everybody. This is a report of what Proactive Disclosure Subcommittee has been doing since the last meeting. We're working on 2 topics currently. The first one is analyzing FOIA requests to identify high-value types of records for proactive disclosure. The second issue is one that came up in a previous meeting, which is looking at the relationship between proactive disclosure and the Section 508 requirements for accessibility. First, with the identifying high-value records for disclosure. At our last meeting, we discussed a study that had been done by a group called Reinvent Albany, which examined FOIA requests to the New York State Department of Environmental Protection, analyzing those requests to find what kind of information was being requested and by whom. At the time of our last meeting, we were discussing this based on their written report. Since then, we interviewed the person who directed the Reinvent Albany study to find out more about their methodology. What we found out was that they were not actually able to go through the log of FOIA requests and classify each one as to what type of records was requested. Instead, they looked at the logs to identify the most frequent filers of FOIA requests, and then they interviewed those frequent requesters to find out what kind of information they typically requested and what they used it for. So that was the basis of Reinvent Albany's findings, that there were just a few types of records that constituted about half of the FOIA requests to this particular agency, and therefore concluded that if those records could be disclosed proactively, there'd be an offsetting savings in reducing the number of FOIA requests the agency had to respond to. We also came across a similar study that's been done even more recently at the U.S. General Services Administration. In this case, GSA was responding to a data call from the Office of Management and Budget, which had asked each agency to investigate how non-government groups were using open data that the government made available. And in order to respond to that data call, what GSA wound up doing was going to their FOIA office to identify the regular requesters and repetitive requesters of FOIA, and then GSA surveyed those identified requesters to determine how people were using the data that GSA did make available. This just brings us to another example that although up till now, most of the analysis of FOIA requests has been in terms of number of requests, speed of service, the number of requests that are partially or fully fulfilled. There's an additional aspect of information about FOIA requests that we see as important, which is what particular records are being requested and by whom. And I think, both in this GSA study, in the New York State study, in our work, and I think more broadly, as the government proceeds in working towards more effective open data and open government, looking at the content of FOIA requests is going to be an important information source for us to be data-driven in determining what data the government should make open that would be high value. We have been trying to do some analysis ourselves of FOIA requests. We have found information on the content of FOIA requests to federal agencies. The one source is the FOIA logs. Several agencies' FOIA logs are available through FOIAonline.gov. There are some other agencies who do not have their logs on FOIAonline.gov but do have logs on their agency websites. And finally, there are federal agencies that, as of now, are not posting their FOIA logs either on FOIA Online or on their own websites. In those cases, the FOIA logs might be available from those agencies through a FOIA request, but they're not being routinely disclosed. There's a good deal of variation between agencies in how well the FOIA logs describe what was requested by each request. Some agencies have, for each FOIA request, or for almost all their FOIA requests, a pretty much verbatim extract from the actual request of what was requested. So in that case, the log is as clear as the request itself. Now, sometimes the requests aren't that clear, but it's nothing the agency can fix. In other cases, we found the FOIA logs and the publicly available records from some agencies give a less usable picture of what's being requested. We've so far found one agency that has actual copies of the FOIA requests available on its website. That would be useful, although when in the cases where the FOIA logs give very good descriptions of what was requested, then that's, I think, as good for our purposes as copies of the actual requests. If Eric is still with us on the phone, then he can describe some work that he did looking at two particular agencies' FOIA information to do a pilot analysis. Are you still with us, Eric?
I am. So we looked at the
slide?
FOIA online.gov website. The most robust data set that was available there was from the EPA. The second most robust data set was from the Department of Commerce. We didn't include the Department of Commerce output in the report today, but we have that information if anybody's interested in seeing it. The first slide that you have in front of you is a word density cloud that just looks at the EPA content. Effectively what we did was we used some technology to very simply crawl the FOIAonline.gov site and pull back every available EPA request that had been posted on the website. And with that content and doing some basic text analytics, we created this word cloud that shows the density and occurrence of each word. At the center of the cloud, you see the more frequent words that show up across the 3,500 or so requests that we were able to get access to at the FOIAonline.gov website. The next slide, next couple of slides show categorically some of the themes that emerged as we looked at the text analysis. The primary category slide highlights the types of substances that, the types of documents that are primarily requested from the EPA. So you begin to start to see themes like substance inventories, citations, claims, lawsuits, determinations. Another interesting observation here are the boundary designations for property lines to determine contamination sites. And we saw that frequently. On the next slide, you begin to see the entities emerge, and we've highlighted a few here. Some of the entities are Superfund sites that show up frequently. You see companies like DuPont and ADM begin to emerge, where there's information most frequently requested about those specific organizations. You see entities like the Sierra Club show up who are frequent requesters. On the next slide, you begin to see the primary categories of chemicals that emerge, and you begin to see a lot of mercury, radiation, radon, biphenol requests. And through this, again, it's a fairly simplistic analysis of very dense documents, but you begin to see thematically these words tell a story about the types of requests that happen most frequently and the information that's in those requests. The next slide is a word density clustering analysis, and rather than look at the individual words, the analytics that we ran looked at the proximity of words to one another. So how often words are associated with each other and how far apart they are in relationship to one another. And those that are circled on the word density and proximity slide, again, begin to tell a theme and story about what we saw as the text analytics began to highlight certain things, and we began to see a lot of underground tank requests and contamination remediation requests, water quality, water supply, wastewater requests, water storage, etc. A lot of remediation requests. And through this, again, the technology is fairly simple that we used here. We began to see these themes emerge that were specific to the EPA, and we have the same analysis for Department of Commerce. We were able to begin to understand the most frequent types of requests, the types of requesters. So we also looked at titles of requesters to look at patterns and begin to see patterns emerging for specific types of requests that could be proactively disclosed if done if proactively disclosed by the agency on a more frequent basis. This analysis is again fairly rudimentary. The data set that we were working with from FOIAonline.gov is relatively shallow. What we would like to do, I think now that we've tested this thesis and proven out that we can begin to see themes emerge with even relatively simple technology applied to the data sets, we'd like to identify an additional data set that might perhaps be a little more robust that we could begin to do this with. And I'll turn the conversation back to David since I'm on the phone. But we're hoping to identify committee members who would be willing to shepherd us through a process at an agency to begin to do these types of analyses with a deeper, more rich data set that might be more telling. And with that, I'll turn the conversation back over to David since he's in the room.
Thanks, Eric. The other issue we've been looking at is one that was raised at the previous committee meeting, and that was the relationship between Section 508 accessibility requirements and proactive disclosure. And what we've done at this point is kind of teed up the issue. Just to review background, some requirements of Section 508 of the Rehabilitation Act. First of all, that federal information technology must ensure that individuals with disabilities have access to and use of information and data that is comparable to persons without disabilities. Secondly, the law says that if making the technology accessible would be an undue burden on the agency, then the agency must provide alternative means of access that allows the individual to use the information and data. And then these statutory requirements are fleshed out by standards that are issued by the United States Access Board, which set standards for particular technological approaches and performance that are considered sufficient to meet these requirements. As a lot of you know, the Access Board is in the process of and was expected to soon issue a revised set of standards that will refer more to existing international standards for accessibility. When looking at the issue of whether there might be a problem in proactively disclosing federal records if they are not already in accessible format, one thing is that most federal records should already be in accessible format. We've been under Section 508 requirements for years now. The Section 508 requirements apply not only to information that the government releases to the public, it also applies to the use of information technology by federal employees. And therefore, our systems are under the requirement to be accessible, whether or not we've been making those records public all along. One example is that whenever we go to our office in the federal government and use the standard word processing software that we have, it produces documents that are supposed to be well adapted for use by software that will read it out loud to a person who's sight impaired. And so a lot of the accessibility has become built into federal information technology by this time. However, that doesn't mean that everything in the government is accessible, that all our records are accessible. For one thing, we still have some paper-based workflows. We all, in our work, I think, run across various cases where the way the work gets done is that there's a paper form that gets filled in and then gets maybe some handwritten annotations on it or some stamps, some rubber stamps, and it gets filed. These paper records are not inherently accessible. Another example is when we produce graphics in order to be accessible to persons who cannot see. The graphics would have to be tagged with alternative text that describes what the graphic shows. In addition, even when a document is accessible originally, when we go through the process of redacting that document, that process typically makes the document inaccessible. The standard procedures, for example, for redacting documents using Adobe Acrobat would produce a file where you have an image of the document with some portions redacted, but the text layer, which a text reading software could read out loud, has been eliminated. And so in that case, if the document is to become accessible again, it has to go through a process of remediation, such as recognizing the text with optical character recognition, adding back tags to indicate the structure of the document, adjust the reading order. There is a memo which some people may be familiar with from the Department of Homeland Security on creating 508 compliant PDF documents, and it describes the process of taking a document which has been redacted in Adobe Acrobat and then remediating it so it becomes accessible again. It's all doable, but it takes some work. At this point, I think because 508 compliance in general is an issue where there's a constant balancing of what works for persons with disabilities and what is practical at any given time in terms of the current state of technology and costs of that technology and the information technology in use by agencies. Because it's all so much about the particulars, I think we would like to elicit, both from my committee colleagues and from the public, specific cases of difficulties that have prevented proactive disclosure of federal records because of concerns about accessibility, and to encourage that feedback of actual cases of problems. We're putting forth this straw man and saying, here's a possible solution, let's find the cases where this would not work. And the two steps are, first of all, proposing that we apply the same standards to proactive disclosure records as to any other publicly available information from the federal government. So those requirements, as with any federal information, the records should be posted in accessible form unless the agency determines that it would be an undue burden. If there is an undue burden, then the agency must provide alternative means of access. We have seen in numerous cases where federal agencies already are making proactive disclosure information on their websites, it's common to see a notice saying that the agency intends this all to be 508 compliant, and if you find that it is not working for you, you should contact this person to explore how the government can remediate that. And then the second point here is we're proposing that agencies should not delay proactive disclosure of records because they are not yet accessible. And that disclosure should happen while the agency proceeds with making the records accessible. So what we're asking for in this case is if anybody can come forward with cases saying, well, here's a particular set of records which have been practically disclosed or could be or should be practically disclosed, but they would cause problems in terms of 508 compliance and accessibility. And we'd like to be able to work with some actual cases to flesh out, what's wrong with this proposal and what alternative principles we should put forward. That's all we have at this point. Thank you very much.
Anyone, questions, comments?
I have a comment.
Great.
Nate Jones. I'd like to thank you for a great presentation, and just quickly on 508 compliance, there are already some government e-stars that have, I think following the course that you set out, posted the vast majority of their FOIA releases online 508 compliant. I hope I don't miss any, but Department of State, NARA, all of the agencies on FOIA online, ICECAP. So there are already people that have been doing this in great work, and we got to get all agencies up to snuff, in my opinion. Thank you.
And that's a very good point. I mean, we do see variation, and I think one good objective would be, since we've seen the importance of the FOIA request data, to find ways to encourage all agencies to come up to the level of the best agencies in terms of describing the content of what was requested.
Anyone else? Questions? Comments? Anyone on the phone? Questions? Comments?
I have a question. This is Ann Wiseman. So can you just detail a little more the kind of additional help, volunteer work you're looking for?
Two things. With regard to the identifying targets for proactive disclosure, as Eric discussed, I think we're looking to work with the members and anybody else in agencies to get the most in-depth data about FOIA requests. So in the cases where FOIA logs may have some requests for which there is not a description of what was requested, we want to at least understand why the description is missing, and if possible, fill it in. If it's available and from some source that we have not yet looked at. So I think what we're asking for with regard to that is, help with fleshing out the data about the content of what was requested from agencies. And then the second thing, with regard to 508 compliance, we're looking for actual cases where a problem has arisen in reconciling making disclosure of records to the public versus only putting forth information to the public that meets the 508 accessibility requirements. So we're looking for people to come forward in factual cases that have arisen or that they see, saying, well, there's this type of records, and we have or would like to or have been asked to disclose them, but we're concerned that we'll be told, well, they're not 508 compliant.
One lead on that, I remember our first meeting, we had an excellent guest saying, if you can fix 508 compliance, this FOIA committee will have been a success. She was from Department of Interior.
Thank you. Anything else?
Anyone? Well, we're well ahead of our schedule. We could take a break, or we could move to our next subcommittee if anyone is interested in taking a break, or no? Let's do one more, okay. So let's just turn to the subcommittee on FOIA fees, chaired by Ginger McCall and Jim Hogan. You all will have about 30 minutes or more, since we're ahead of schedule, and we'll go ahead and...
Great. So we held our meeting once again at EPIC's offices. We held it on December 3rd. The members in attendance were Jim Hogan and myself, Ginger McCall, Ann Wiseman, Karen Finnegan, and Dave Barr. Krista Lemelin was also there from OGIS. Oh, and Nate, apparently, which we'll have to, I guess, amend.
Yeah.
We'll
post the updated version of those notes online.
Great. So when we had met the first time, we discussed potential areas of research. And some of those areas of research were looking at the current status of court precedent regarding the three designated special categories of requesters, so news media, educational institutions, and non-commercial scientific institutions. We were going to look at the case law around that and try to find out whether or not there was any real clear definition of these things. Because one of the problems that we noticed for FOIA officers within agencies that's creating inefficiencies is that it's very difficult for the officers necessarily to have any consistency and real guidance about who falls into these categories. And this also creates problems for requesters, because a requester may sometimes qualify for a category, and then if they make a request to a different agency, or even within the same agency, they may be denied special fee category status. And these fees make a huge difference to requesters. They can be thousands or even tens of thousands of dollars. So we decided that first we were going to look at case law precedent around these designated special fee categories. And second, we were going to look at how other countries around the globe deal with fees, particularly fees in regards to large requests, voluminous requests, or frequent requesters. Because one of the things that was raised by several of the FOIA officers who were in this meeting from the government side was that the fees are used as a tool to encourage requesters to narrow their request and to discourage what they called vexatious requesters. So for this meeting in December, we looked first at the summaries of the fee provisions in access laws in Australia, the United Kingdom, Canada, Mexico, and New Zealand. And we included a table of our findings within these notes here from the meeting. What we found, in short, was that laws on fees are all over the place. It's difficult to see any sort of real pattern in worldwide access laws. So we weren't able to necessarily find a solution there. And we talked about it, we discussed at length the pros and cons of these different fee structures that were set up in countries. For instance, in Canada, there's a flat fee of $5 charged. Other countries allow agencies to designate a requester as vexatious, or they give a certain amount of search time as free. So there are a lot of differences around the world in these fee laws and in the way that agencies deal with voluminous or what they would call vexatious requests. So we talked about the perceived advantages and disadvantages of each country's fee structure, and we also considered whether or not those countries actually had a structure where a person would have to go into an office and search for documents themselves, or if they could make a request and then have a government officer search for that request, or search for those documents. Next, we moved on to reviewing the U.S. standards for favored requester categories. I had a couple of memos prepared by some of our interns looking at law specifically in the D.C. circuit for what qualifies as a news media requester, who would qualify as an educational institution, who would qualify as a non-commercial scientific institution. We also looked at agency regulations to try to find out if there was any firmer guidance there. And the conclusion that we came to in this meeting was that the categories are often ill-defined and they're confusing to both the agency and the requester. And this, I think, accounts for a lot of the time that's spent on fees, and perhaps we figured this accounts for a lot of the contentiousness around the fees issue. So then we talked a little bit about some of the proposals that were made originally. One of the proposals that we had made, that was made in the very first meeting of this Federal Advisory Committee, was the idea of just eliminating fees altogether for all non-commercial requesters. So we talked about the advantages and disadvantages of that. The primary advantage of this would be a reduction of time that the agencies spend on adjudicating fee issues. So figuring out who would fall into a favored requester status, who qualifies for fee waivers, all of that time would be reduced. It would also, I think, really benefit requesters because requesters wouldn't have to worry about the financial burden that they may have to shoulder for making a request. It would allow agencies to focus their resources on the actual processing of the FOIA requests. But within the group, within the subcommittee, there was a lot of discussion and a lot of concern around the potential risk of FOIA requesters flooding the agencies with requests, especially voluminous requests, because they would no longer have to pay processing fees. There was some speculation that this could increase agency backlogs or response times. So it was noted by some of the governmental members of the subcommittee that there is a history of a small number of requesters flooding the agencies with requests, that a small number of requesters end up accounting for a large percentage of the agency's work time, and that given this history, the elimination of fees may make things worse. Other nations, as noted in our research, had labeled these types of requesters as vexatious, but for understandable reasons, some within our subcommittee group found that term to be problematic. So we decided that we would use the word extreme instead. Currently, agencies don't necessarily have a tool in their toolkit to deal with extreme requesters or very frequent requesters or voluminous requests. So several nations do have within their access laws sections dealing with vexatious requesters. Specifically, Australia and the UK and New Zealand approach this issue, though they do it differently. So we created a summary of those approaches, and it's in the materials. Different countries define vexatious in different ways. In some countries, vexatious, quote, vexatious requests don't have to be honored. It differs within the countries who gets to designate a request or a requester vexatious. So it seems around the world there's not a lot of agreement about this. So we talked a lot about that and the applicability or necessity of a similar provision in the US. There were a lot of concerns on the part, especially of the requesters, of requesters being unfairly deemed vexatious. Perhaps some of us up here might be deemed vexatious. And so the potential of mischief by the agencies in labeling a requester. The difficulty of objectively defining an extreme request or a requester. It seems like this is comparable to the difficulty of defining news media. The potentiality of foreclosing access rights to the public because of a few bad apples. We decided that it does seem, the subcommittee decided that it seems advantageous to have an independent authority make this sort of designation instead of an agency, but that this would ultimately add significant time to the process in making a determination, so it may not end up being any more efficient than what we already have. Other potential ideas for fee improvements were then discussed. We talked about modeling a system that has a single low uniform fee, something like Canada, that would be paid by all requesters. This would make requesting more affordable across the board, and it would eliminate the time spent by FOIA officers on resolving fee category issues and potentially discourage extreme requesters. We also talked about a scheme that would by default make requests free of fees, except if the documents implicated by the request passed a fixed threshold. So for instance, a 10,000 page threshold. This would eliminate agency time spent assessing and collecting fees, eliminate economic barriers for most requesters, and help discourage overbroad, burdensome requests. So the attendees debated the merits of each of these claims, but ultimately decided that the discussion was lacking necessary information about the actual burden created by extreme requests, existing agency mechanisms for dealing with broad or frequent requests, and the actual amount of agency time spent assessing or collecting fees. So to that end, we decided that we'd like to do a survey of FOIA officers. We agreed that the questions should center around two general areas. The first area would concern fees and the determination of how extensive they are as an issue, if at all. And the second would explore large and burdensome requests and agency mechanisms for dealing with those requests. And we plan to hold our next meeting again at EPIC's offices in February.
Thank you. This was very informative.
Oh, and actually to that end, on the topic of the survey, we will be reaching out to members of this advisory committee to get some ideas about questions for that survey.
Great. Anyone comments?
Yeah, go ahead. Quick comment. I think some good news is due to...
If you could please...
Oh, Nate Jones. Due to posting our documents online ahead of time, the FOIA listserv already has read these and has a very active and very good discussion on this topic. So I recommend all of us to go read and perhaps chime in and certainly take their views into account. So it's already creating a good discussion.
Yeah, and just to jump in here and put in another plug, we really want the public and federal agencies to share their thoughts and opinions on us. So please visit www.ogis.archives.gov and go to the FOIA Advisory Committee section of the webpage. And within that, there's information on how to submit public comments. So please do that. Please be part of this important conversation. Your thoughts and opinions are very important and will inform the work that this committee does.
Yeah, it would be great to hear from members of the public, people within agencies, others in advocacy groups about potential solutions for this problem, taking into account both the agency's interests of overly burdensome requests, but also the requester's interests in more ready access and not having overly large fees.
Yeah, I was just going to add one thing that was striking to me, this is Ann Wiseman, sorry, is that I think it's perceived as a problem or issue from sort of both sides, if you will. Both requesters and agencies, I think, are really struggling with this.
Yeah, and one of the things that we talked about within the subcommittee on the side of the requesters is that if you're a requester who's making reasonable requests and then you're dealing with a backlog that's created by large overbroad requests or requests by very, very frequent requesters, it ends up putting you at a disadvantage as well.
Nate Jones, just two more quick points. One, I think there's a lot of agreement that no matter what the problems are, one of the problems is that there's no real standard and that standards for fees fluctuate from agency to agency. And that's a cause of the frustration. And my second point is that, to my surprise, actually, the end appeal stage of mandatory declassification review, which is in some ways parallel to FOIA, actually does not do, they don't charge fees and they don't do a first in, first out basis. They actually prioritize. So frequent requesters sometimes go to the end of the line by this body at NARA's opinion, which is an interesting model to study. In some ways it's successful, in some ways it might not be, but it's certainly, in addition to around the world, so we can look here at home as well.
Larry?
Yeah, Larry Gottesman. First a question, first actually a comment and a couple of quick questions. I can tell you from EPA's standpoint, we don't look at the size of the request in making fee waiver determinations, except when we get those requests. I want all records in EPA involving clean water or, you know, back up a truck. So we really don't look at those. Secondly, the memos you mentioned your staff did, are those available on the website?
Yeah, I can send them along so that they can be put on the website.
And our biggest challenge is the educational category, because we see most students in college and high school now feel they're educational, and I think that's really a big challenge we all have, is to determine when they're really educational, when they're just sort of doing a paper, when they tell you, you know, I need it tomorrow because I haven't done my research yet. It's pretty obvious where they fit, But that's always a challenge to agencies, is when these educational requesters come in, are they really requests on behalf of the university, or are they really just a student making a request because they want some research done for them?
That's a good point. And, you discussed, this is David Reed, you discussed what you call extreme requesters, what some other people have called vexatious requesters, but there's also, I think, in a lot of cases, an issue of what you would call frivolous requests, where it is a student, doing their term paper and kind of mechanistically filing a FOIA request with a federal agency. And the question is whether, whether as a matter of policy, the government should be dedicating resources to processing that request. And right now, the only way it's discouraged is by fees. I'm happy to see that you are coupling the fee issue with the issue of reviewing whether requests actually should be processed. And if there was some way to do that that was not subject to abuse of, of putting aside the requests from the government's opponents, then it seems that would be better all around than using fees to discourage some requests.
I can't speak for the subcommittee, but just to speak from a requester standpoint, I would think actually that a request by a high school student or a university student, we would actually want to encourage that. That to me seems like the exact sort of thing that we would want to encourage under this statute. It's important civic engagement by young people.
Yeah, this is Ann Wiseman. Let me just also add, I think it would be very dangerous territory for the subcommittee to go down the road of creating standards for what a request that an agency should or should not entertain. I mean, the law is pretty clear. It's a right that the public has, period. Really, the only issue we're talking about here is fees. And again, I mean, there are fee requirements and standards built into the statute, but nevertheless, the experience of people on both ends is that they've been very difficult to implement. And so we have focused on what I guess I have to stress, I think is a very, very narrow subset, which is very, very frequent requesters, which doesn't really look at the merits necessarily of any independent request. And as a member of this committee and subcommittee, I would be adamantly opposed to going down that road. I think it would be entirely inappropriate.
Yeah, and the reason that we were looking particularly at this idea of vexatious requests is because the initial proposal was, let's get rid of fees. Let's get rid of fees for all non-commercial requesters. The agency pushback on that has generally been fees are an important mechanism that we use to discourage irresponsible, extreme, vexatious requests, which end up creating more of a backlog, which hurts everyone, both at the agency and the requester community. So fees are the tool that the agency uses to discourage those requests, or when they receive such a request, to encourage a narrowing of a very, very broad request. So I think it is an important conversation to have whether or not these extreme requests really are a problem for agencies. And it's difficult to get at that by looking at the current reports that are up on FOIA.gov. We haven't been able to figure out exactly how many requests really are voluminous, very voluminous, how many requesters really are vexatious requesters or extreme requesters, someone who's making a request every day or every other day. So we're trying to get a handle on exactly how much of a problem is this really, because if it's not that much of a problem, then perhaps this idea of getting rid of fees for non-commercial requesters is a viable idea. When we end up looking at the amount of time that agencies spend processing fees-related issues versus the amount of time that's spent on these requests, perhaps it comes out one way, perhaps it comes out the other, but the way to get to that, we hope, is to do a survey.
And Jen, this is Larry Gussman. You've said it now 3 times, and it really offends me. Agencies, I can tell you, most agencies do not make determinations on fee waivers based upon the size of the request.
Oh, no, I'm not saying that they make a determination on the fee waiver.
We don't but we also don't look at fees as a way to encourage requesters to limit their requests.
Well, that's different than
I can tell you, at
what we
least
were
I can
told by
speak.
the people within the subcommittee. I mean,
Okay.
this is something that the officers
I understand,
themselves
but
said.
I can just say, at EPA, I can tell you, we do not make that decision. Clearly, we've never said, oh, because this request is going to take us 300 hours to process, or we call it the 100-year request. We would never go back and say, we're going to come out with a number because we're going to try to discourage you. I mean, we will give them valid numbers if they want to limit their request, except for those requests asking for all records of EPA involving clean air or clean water. I mean, those are just beyond, anybody's relative reasonable request. But
And this is what we're hoping to get to in the survey. I'm not.
No,
I'm also saying, from an outsider's perspective, I was not the one who came up with this idea that fees are used to discourage broad, voluminous requests. It was something that was raised by the FOIA folks, the government side FOIA folks within the subcommittee.
Okay, that's fine. Just the other side of the coin is we've never done
And
that.
I hope that this is what we'll get to in the survey, is to be able to look at the different ways that agencies deal with these requests and with fees.
A lack of uniformity government-wide because other FOIA just said on the record that they have.
Right, and which goes back to the encouragement of one central set of fee structure for the whole government.
But again, this is Ann Wiseman. This is raised as like a common response to the proposal to get rid of fees, which is that then what do you do with these extremely large? So I think, I can't stress enough, I think the first step is this a real issue?
Yeah.
Or again, is it a straw man issue that we're dealing with? And that's really, I think, the first step that we need to figure out.
And it would be helpful when we get that question from folks on the government side, oh, well then how, if we can't use fees, then how do we deal with these requests? How do we deal with an overbroad request that we want to be narrowed? If there's an agency that has a great way of dealing with this, if you have a way of working with those requests, of encouraging requesters to narrow overbroad requests, or perhaps overbroad requests aren't that much of a problem at all, actually, for your agency, it would be helpful to hear that.
Hi, this is Jim Hogan. Could I speak a little bit?
Of course.
Okay, good. I want to make sure it's working here. I want to be careful not to couple fees with discouraging. Of course, we don't do that. But I think a reality is, for a FOIA officer out there, that whenever a request that clearly does not qualify for any fee waiver, and it's the person does not have the ability to disseminate, does not demonstrate it, etc., and it's a large request, sometimes that is used as an encouragement to the requester to help narrow and focus the request. And that's sometimes a difficulty with a lot of FOIA officers, whether it's somebody qualifies for fee waiver or not, is encouraging the requester to focus the request to get the information they want in a reasonable amount of time. And I think that's part of the difficulty out there. And understand FOIA requesters don't understand how the filing systems are, so they'll say, I want everything and anything on a certain subject, such as what Larry was talking about there. So that, I think we're going to be able to get some feedback once we have the questions to the agencies in that how do they deal with that? And of course, for any request, for a lot of requesters, especially if they qualify for a fee waiver, the primary encouragement is time. We can, the more focused, more narrow you are, the more we work with you, the quicker you can get the information.
Hi, this is Karen Finnegan. I'd like to support a little in a different way what Jim is saying, in that I think there's a common interests when an agency and a requester can talk about the scope of the request, because the requester wants to get the information as quickly as possible, and the agency also has an interest in processing the request as quickly as possible so they can close it and it's not part of the backlog. But I think that the perception that's coming out in everyone's comments is the one that we started with, is there's acrimony in the fee issues in FOIA, in the FOIA world. And so in addition to the detailed work we're trying to achieve here, I think we also have to try to change the perception and the approach that seems to be common from both the requester and the agency side when they're talking about fees.
This is Ann Wiseman. I think that's a very good point, and I think data is what will help us get there.
Totally agree. So to that end, we invite people to propose survey questions. We'll put together, I think, a list in the next few weeks and then perhaps email them out. Maybe we can get those posted up on the website for this committee. and solicit response on those questions and see what people think.
This is Mark Zaid. Depending, of course, on whether there's a decision that fees should be eliminated or not, is the subcommittee looking at trying to better define the category of potential fee requesters?
I think that those exact goals will probably be refined once we've actually seen the data from the surveys. It's difficult to say right now what the goal should be.
So I know one of the issues, as I've looked at for a number of years, particularly for a number of the groups that we represent in the nonprofit world, you know, I've even struggled with trying to figure out exactly how some of us are either news media or educational. I mean, we're clearly should be entitled to fee waivers, and we're the type of groups that the statute presumably was designed for, but the category really isn't there. And I mean, to the agency's credit, they've shuttled us into fee categories that we probably shouldn't be in order to get fee waivers, because we're just don't exist there. There's no nonprofit for the betterment of education and dissemination of public information. So if you do, obviously if you don't decide fee waivers should be eliminated, that's something I would probably suggest you look at.
Mark, this is Nate. I've heard people, well, my telephone friend.
I know you just don't have to tell me that you're Nate. I know you're Nate.
I've heard people batter around, it hasn't happened, just adding in if an organization is a 503C. Then they 501c3, thank you, and then they would only pay reproduction fees, which is.
I think, I mean, that's an idea that I've supported for a while. I think it might be a good middle ground on this, but we'll have to see what turns out from the surveys.
Now, the other thing, this is Mark Zaid again. There was, sometime last year, someone FOIA'd some document from the FBI, and I want to say it said it was vexatious FOIA requesters, because I was on the list and I wasn't quite sure why exactly I was on the list. But I was curious at least whether you saw this from the other countries or here in your discussions with the agencies, whether it's vexatious or extreme. I mean, to me, there's a significant difference between someone who's submitting a significant number of requests, but every one of them could be legitimate and substantive and entirely appropriate, but there's just a million of them. I mean, anyone who does FOIA litigation knows that some of the worst FOIA decisions are by vexatious litigators, usually prisoners, that end up having bad decisions because, quite frankly, the judges just want to get rid of them and then eventually ban them from doing any further litigation. But they're submitting FOIA requests about, okay, what kind of toothpaste are we getting here at the prison, and which I suppose could be something good in some ways, but every year, every day, whatever. But I wonder if you're looking at the notion of, you know, maybe this would be the survey question. What do agencies mean by requesters that are submitting a significant number of requests? What's causing them the problem? Is it the number of requests, or is it the substance of the request, the frivolity of the requests? I mean, we all know here some individuals who I won't name who are incredibly, I would say by definition, vexatious if you go by volume, but this one person in particular submits fantastic FOIA requests that end up actually all over the news because of the substance that he ends up receiving. But I certainly know of some agencies that would love to shut him down just because of the number of requests, but that's what the statute's there for.
This is Larry. But I mean, the flip side is we now have a new requester who's on our way to EPA who's making between 20 and 30 requests a day, every single day for, you know, information regarding. I think he's working his way through Congress, to be honest with you, in the Senate, and so it's just becoming, you know, for other folks, it's becoming a challenge, because if he's going to make 435 requests, which is my guess is what he's doing, then he'll start with the members of every congressman and every governor. It sort of puts the agency in a difficult position, because do we process his basically 500 FOIA requests, or do we process, you know, where do they come? And if you're doing first in, first out, your staff limitations are there. So they're reasonable requests. I mean, they're faced, but they're like, I want every FOIA request or every document in the agency regarding Congressman X. And it's just a challenge to agencies.
This is Ann Wiseman. The one caution I would say here, it's not to agree or disagree with any of the remarks that have been made, but the subcommittee is looking at the issue of fees. And so we do have to make sure that that remains our focus. I mean, obviously it's touching on broader issues that, you know, with more time may be appropriate for this advisory committee or any of the subcommittees to look at as well. But I think just keep in mind that we're looking at it through the narrower lens of the fee provisions.
Excellent comments. Thank you all. Anyone on the phone? Comments? Okay.
Nikki, could I add just one more last-minute comment? So I think the work of this committee...
If you would please state your name.
Yes, Marty Michalowski from the CFPB. I think this is important work. I'm interested to see what updates come to the OMB guidance and just other general guidance as well, because I think that's about due for some.
Overdue.
Yeah.
Yeah. And I say that in a different perspective. I follow what kind of Larry has pointed out as well, that we don't charge a lot of fees and we find other ways to work with requesters. But we're going through our regulation rewrite after 3 years. We're updating it again. And one of the things that I wanted to do was really look at fees and, if you want to say, relax them or take a different approach to them. And what I found out was that I'm limited in that approach because of some of the guidance that is out there. So if I want to, for lack of a better term, automatically waive fees below a certain threshold, or don't charge fees, or get rid of duplication fees and do those type of things, I'm limited because there is already rules out there that I have to abide by, or my regulation would contradict the government's rules, so to speak. So I'm very interested to see those things change so that agencies out there that do want to change things are able to do that better and more quickly, and really focus on, you know, looking at fees in a more holistic approach to benefit both agencies and requesters.
Yeah, I think that's a very good point.
Excellent. We can go ahead and take a break. We are way ahead of our schedule. You know, upon return, we will only have one more subcommittee to do their report.
So let's come back at 11:30 and we'll have the Oversight and Accountability Subcommittee report and public comments. Thank you.
Yeah.